This is the title of my presentation, my humble presentation, which is Regulation EC 1896-206 of 12 December 2006, creating the European Order for Payment Procedure, EOP. Well, I will try to show you the performance of this initiative from the European Commission and the main issues, to me, of this initiative. The scope of the initiative from the European Commission is very well-hearted, I should say, and of course he tries to ensure a swift and efficient recovery of outstanding debts, which is a very good scope, and I think it is a good achievement to get by. This procedure is uniformly applicable in the different member states, and it's autonomous, optional, and additional to the national procedures, which is a very good idea. I mean, the idea is to combine the two different procedures, the procedure from we can say the inside the national regulation and from outside the national regulation, to ensure the easy way to recover the outstanding debts within the European Union. So this kind of combination of two different procedures is a good idea in principle. We will see in the near future that, well, of course, it has some kind of troubles and some kind of issues, but the main idea is very well grounded. Because this European procedure does not substitute itself the existing national procedures and is optional in consideration of other existing European mechanisms. That, of course, there's a lot of them, but this tries to break away or to open up a new system, a new procedure to these small claims, these outstanding debts, which is very difficult to undertake into different procedures, normal or average procedures within every country. So the idea is to, well, not substituting the existing national procedures, but to introduce another way, which would become the same throughout the European Union, because its purpose is to simplify, and I'm reading exactly at the beginning of the ruling, what it says is to simplify, speed up and reduce the cost of litigation in cross-border cases concerning uncontested pecuniary claims by creating a European order for payment procedure and to permit the free circulation of European orders for payment throughout the member states by laying down minimum standards compliance, with which renders unnecessary any intermediate proceedings in the member state or of enforcement prior to recognition and enforcement. Well, the main consequence of this procedure is the regulation. In fact, fortunately, I should say, is abolish the exequatur, which is a very old tool, a very overridden tool to get along with this outstanding debt, with this kind of speed, with this kind of swift procedure to recover this outstanding debt in the cross-border litigation. So it is a good idea. It is a much more good idea to establish an average procedure throughout the European Union. And it's also a very good idea to abolish a very old tool like the exequatur and to try to get standards, the minimum standards. Let's see that this is the main problem within the European Union. Established standards is a very harsh question, because our legislations are very different from each other. So sometimes it gets hard to to accomplish with this minimum standards. So, well, it's easy to say, well, let's find the standards, but sometimes it's not so easy to bring this idea into ground. So the first question is, does mark the regulation a major milestone in the European judicial cooperation? And the answer should be yes, it is. It is, to me, it is a major milestone in the European judicial cooperation, because in the civil procedures, which is relatively new to the juridical acquis of the European Union, these civil procedures usually were not very well developed. So this is the beginning of, to me, this is the beginning of a new procedural law for all the European Union in the near future. And well, of course, being a very good idea and marking a major milestone in European judicial cooperation, the first question, say, is it does not improve. It does not. It's not a very. It's not really new, because it improves some previous regulation. We had some previous regulation. For instance, the regulation number 805/2004, establishing a European enforcement order for uncontested claims with a relevant methodologies, no major contribution. So it's a good compilation of ideas. It is a good compilation of tools that were already given to the juridical world within the European Union for in civil procedures, but it's not really absolutely new. It's just a combination. It's just a compilation of different initiatives that have been taking place before, were introduced in this regulation as a step forward to get along with the idea. So not being completely new, yes, it's a major milestone, but that's the dark side of the initiative. It lacks some technical deficiencies, and these technical deficiencies are are not minor, if I may say so. It has some serious deficiencies that in some way they contribute to scale down the initial scope of the ruling. So the idea was very good, and but it was very well constructed, taking into account different laws that were already in the judicial acquis of the European Union. But the deficiencies we're going to talk about next words, you'll see that they scale down a little bit the expectations. It has contradictions, it has interpretative difficulties, and it introduced the exceptional appeals, which doesn't go very good with the idea of a swift, regular, not contestable, if I may say so, and well, not very easy to challenge. So the idea is to bring out, is to offer the juridical world or the civil world with a regulation very speed that brings us a very speed to get along with outstanding debts. But on the contrary, the introduction of exceptional appeals, well, does as I said before, does scale down a little bit the expectation. Something swift, something foreseen to speed up the claimants of outstanding debt shouldn't be that easy to challenge. You see here the achievements the achievements of the initiative, well, this is the positive side of the ruling, and of course it has a lot of achievements that should be underlined. It ensures full compliance with European procedural principles. This is very important because, as I say, sometimes it gets so hard to combine different principles, different procedural principles among the different countries. Actually, we don't count on the UK, for instance, which were such a headache to combine with the civil procedures of the continent. But anyhow, sometimes it gets hard, for instance, between the different legislative philosophies or legislative principles in different countries. For instance, between France and Italy and Spain and Portugal, for instance, it's quite easy to share the same legislative principles because we do belong to the same root. We don't the same principle, which is the Napoleonic Code. But in other countries, northern countries mainly, it's not so easy to accept. It's not so easy to standardize these principles, those principles in the northern countries, for instance. So the introduction of a legislative form ensures that any country, every country, will use the same principles. This is a very good achievement. Not any country is going to say, no, my principle, my own principles, my private principles are those, are these, are legislative form doesn't allow the opportunity, doesn't give the opportunity to call different legislative principles. Legislative form is applicable to all countries. It's of course a following up of previous regulation to gain uniformity. This is a very good achievement. The main principle is to provide same procedure, same proceeding for same kind of claimings, some kind of principles, and those you are going to use the same tool. Everybody is going to use the same tool for the same purpose. The abolition of the sequatorial, as we were talking before, is another intermediate procedures. Is a very good achievement to me. I think this is the main gaining in this arena. The automatic recognition of foreign decision is also a very interesting feature, and of course, although it's not very well done in practical sense, the idea it's very well formulated, and I think it's this automatic recognition. It's a major goal of the procedures. There's no way to refuse informants, and this is also a very good achievement of the ruling. There's an exception. There's an exception we're going to analyze in a couple of minutes, but in principle, the difficulties to enforce a decision, it's a very good idea, and the more difficulties, the more easy it is to get along with the claiming, with the claiming of the debt. So in fact, it's more practical and more easy. So well, that's a good idea. That's a good achievement. The abolition of duality of systems provided by the Article 7, 1348, 2004 notification, it's also a very good achievement. There were some difficulties in this area, and this duality of systems finally were turned into just one, and this is of course something to celebrate. The use of forms is also a very good idea. Proceedings and procedures inside the European Union are quite different. And even if you are calling for some standard proceeding throughout or within the European Union, the difficulties to interchanging papers or to presenting claimings or to ask for some kind of documentation or something like that. It's quite it turns things quite a bit complicated, and the use of forms is a very good solution. The using of forms in this regulation, it's a very practical way to salute the differences between the internal and or the national proceedings. In one country, civil procedures could be desperately written, for instance. In another could be surprisingly oral. And between these two systems, there's a lot of different stages and or different possibilities or examples. So the using of forms, it makes things so easy, much more easy for people who decides to present a claiming for outstanding debts. So the use of forms as a mandatory system to interchange information or to ask for a judicial act, it's a very good idea, and I think it standardized the procedure, which is really good. The participant use is also an achievement. I think it's a non-dominatory, as in the major countries or who counts on this kind of this type of procedure. We call in Spain monitorio, which is some more or less the same idea. It's a protestative use. You can go to an ordinary procedure. You can present your claim, present your paper claiming for some outstanding debt in an ordinary way, an ordinary procedure, depending on the amount of the money claimed normally. But you can protestatively use this petition, this kind of procedure prior to decide whether if you go into an ordinary procedure with the help in the average cases of a lawyer, or not, or you are just to present this type of claimings to see how it goes. So the participative use allows the litigant to decide whether it's better to go to a swift procedure, a much more simple procedure with some risks we're going to about to see, but on the contrary, if you decide to go to an ordinary procedure following the rules depending on the nature of your claim. The other achievements we noted it before is this. We're talking on the same procedure throughout the European territory. So this standardization of a procedure, a civil procedure, is a major achievement to me. And also the equal protection of rights throughout the EU territory. So it's not only the procedure, it's only the protection that the procedure gives to every citizen within the European Union to claim his own debts. Provision about court fees, it clarifies also the difficulties regarding the cost of these kind of procedures. The solution is a legal one, so it will not depend on courts, it will not depend on countries, it will not depend on different possibilities. It's just a standard system, and well, it's clarified from the very beginning. There's also a procedure for remedy deficiencies, and it is a very good idea also because sometimes, as you're probably aware, difficulties to present these cross-border claimings is the difficulties to get along with in a formal way, in an adjective way. So you can find that your claiming in your own country would be perfectly well done, perfectly well preferred, and in your neighbor country, it will lack some kind of paper or formalities or whatever. So, the solution given by the ruling to provide a procedure for remedy deficiencies, it's a very, very good idea, because no problem, no deficiency will provoke your claiming to be struck out. On the contrary, it is possible, absolutely, to remedy your deficiencies with no procedural cost, if I may say so. So you can, in any case, you will have in any case the possibility to remedy your potential deficiencies in your claiming, in your form. So it is in favor of the action instead of in favor of well, if I find a minimum error, your claimant will be struck out. So well, this is also a very good idea. And also, it's a clear procedure to determine jurisdiction, which is good also, because sometimes difficulties come from the competences involved in this cross-border jurisdiction or this cross-border cases. Sometimes it is difficult to determine jurisdiction. Depending on the matter, depending on the country, depending on the well, all these issues regarding the competence, and the jurisdiction. It's not given to a very complicated procedure, but to a clear procedure to determine whether one country or whether other country are competent to solve the case. Let's go now to drawbacks and difficulties. So far, we've seen a lot of very good ideas, or at least good ideas, and how the legislator took into account some of the traditional difficulties in cross-border litigation. But the drawbacks and difficulties come from the fact that some of the good ideas on paper are very difficult to get down into the earth, into the reality, and to how to solve the difficulties is not always as easy as the legislator thinks. Because sometimes you will find a judge, you will find a lawyer, you will find someone who has more imagination, or who has more time to think on how to cheat your petition, on how to find the difficulties and possibilities to fight this idea. The extent of the evaluation competences to examine the AOP is the first and very most important difficulties in the ruling. Evaluation competences is to, in fact, it means giving the judge the possibility to find a way to reject the AOP. That's, if I may say so, is allow or give the opportunity to find the straits, or to find the weakness of a petition, or even the weakness of the ruling, to reject the petition. So extending the evaluation competences is to bring out to me a non-desirable opportunity for the judge to reject. To me, it had been much more interesting to go for a more objective way to examine the competences, to examine the EUP, to examine whether the EUP it's well or not well grounded, or it should be or it shouldn't be admitted. But on the contrary, the ruling gives the judge, to me, a wider possibilities that had been that shouldn't been taken into account. Well, so this is to me a principal drawback of the ruling. The susceptibility of action against rejection of the EUP is also a problem, because well, one problem is to give the judge the possibility to examine the EUP and to give him the possibility of evaluate its own competences, for instance. But whether it should be his decision if you gives the litigant the possibility to challenge the rejection of an EUP. What you are doing in fact is to widen also the possibilities of the possibility of, I mean, to make the procedure more long, more duration could be under these premises could be a bit much longer than it would be desired. First, the possibilities of evaluation competences. Second, the possibility of challenge the decision on the competences or on jurisdiction or whatever. And these are a combination of two dangerous, very dangerous possibilities. The more procedures, the more time you give the parties, the more time you give the judge to decide, the more time this can get the whole proceeding a bit much longer than would be desired. So the third drawback of the ruling is the notification, or how the notification of the EUP is to be done. Notification of the EUP, it appear to be a much more simple question, but it's not. Notification of the EUP is a very key question, because notification of the initial petition, it's the key to the following steps. How notification is to be done will determine whether if it is possible to get along with the EUP or to enforce the decision taken by the judge, and or not. So how the notification is to be done is crucial to see if the procedure is to take place, is to follow up, or is to turn into an ordinary civil procedure. And moreover, the problem is notification depends on the different national states. So this brings, contrary to the general idea of establishing a standard procedure, we will find a weak point in this subject. Well, the procedure, yes, it's a standard for all the European Union, but notification, the ways of notification, will depend on the principles that are set in every national legislation, procedural legislation. So this seems to be a bit contradictory. It's a small or a big contradiction. Well, we'll see it more detail in the future. Now, another drawback is the limitation of subsequent ordinary civil procedure. It is not very well. It is not very well foreseen in the ruling, which should be the ordinary civil procedure after the party claimed has brought up or has opposed to the EOP. It's not well defined what kind of civil procedure is to take place after the EOP has been challenged. It's not very well. It also, the ruling says or drives the procedure depending on the national legislation. So, we're about to see which are the details of this small drawback. The enforcement of the EOP is also in final the main difficulties, because yes, the ruling constructs, let's say, the whole procedure, but once the EOP it's finally set up, the enforcement of the EOP goes again under the national procedural laws. So sometimes it's very difficult to accomplish with this idea. Sometimes the enforcement of the EOP is as hard as enforcing a general decision in the civil procedure under national legislation. So sometimes you will get a clean and smooth and brilliant procedure to get a decision, in this case, the EOP and the order to enforce, but difficulties began from this point. And yes, I have the decision, I have the title to enforce my debt, my law, my rights, but how I'm going to do it? Does the national jurisdiction have the means, have the a good mean to bring things into reality, to pay the amount debt properly or not? Sometimes this is also a difficulty. The last drawback is scarce use, and this is a how can I say? It is not a drawback, properly speaking, but it also well, a shocking reality. And despite being in force for 15 years, it appears to be not the EOP. It appears not to be very well known by professionals, by lawyers, citizens in general. Its use is scarce, and in most cases, due to ignorance, some professionals are not familiar with the procedure, nor judges, and it's not friendly to them. And why it is so? The scarce use of the procedure, the scarce use of the EOP, will it make us wonder why it is for. And I think as well, under practical principles, I should say, scarce use is always due to a not very well suitable tool to accomplish what he's built to. Normally, you are not going to use something if it doesn't bring you good results. And well, you can think in 5 years, in the first 2 years, well, it's normal that people in general, lawyers, judges, citizens in general, they don't know the tool and they need some time to get used to it. Yes, that's true. But after 15 years, it's not that easy to think that it's a question of time. The progress made by this procedure is absolutely huge in philosophical or in practical terms, or as a major step beyond to a new civil procedure within the European Union. But it will save, of course, in principle, a lot of time, a lot of money for professionals. So if they don't use it, to me, it's clear that something is not working properly. Something's happening that has to see with the probably, and maybe I anticipate in some conclusions, because the enforcement is not easy as it should be, or maybe the difficulties between the different lawyers from different countries, fine, with different judges, and so this desirable standardization of procedure is not finally very well grounded. Well, I don't know. On my time.
No, your time is okay. You can continue. We are following. I mean, you have it's like till 7:30, so no problem with timing.
Okay, thank you very much, Marius. Thank you very much. I would like to show you here the extent of evaluation for the courts of the country of origin. We said that this could be a problem. This could be a major issue, and I'm going to firstly to show you what the Article 8 says of the ruling, and which are the content of the provisions of the legislative provisions, and what are the practical activities to this. The Article 8 says that the court should examine as soon as possible the petition. Yeah, well, it doesn't mean a lot. Verify if conditions laid down in numbers 2, 3, 4, 6, and 7 are met, and verify if the application is well grounded. Which are the practical activities involved in this Article 8? First, some subsumption of the application within the scope of the regulation, of course, excluding matters specified in Article 2, Office number 44, 2001. Yes, the court has to see whether it has or not jurisdiction following the EC number 44, 2001. If the debt claim meets the condition on amount, expire date, and enforceability, and if the application fulfills the requirement of Article 30 regarding the use of forms. Well, this it seems to be nothing in particular, but you'd see that, for instance, number 3 of Article 8, it's a bit tricky. Let's see. If the application is well grounded, what is this? What it means well grounded? What do you mean well grounded? The judge has here no rulings, so no idea of what's the meaning of well grounded. It's an indeterminate concept. And it's very dangerous. It's very dangerous because it seems to say a very well-grounded petition is that who has an appearance of how can I put it? Goodness of feasibility. And yes, you appear to be a well or a creditor, and it appears this appearance of your credit appears to me to be well grounded. So the document you are invoking, or the papers you are giving to me, or what you say in your form, it appears to be well constructed. It appears to be your debt. It seems to be real, and it seems to be well founded and well done. But even so, this keeps to be an indeterminate concept. And that's a problem, because the Article 12 says the defendant should be informed in the EOP that the injunction was issued solely on the basis of the information provided by the applicant, without having been verified by the court. So how can you combine these two different regulation? If the court is not to decide anything but to test only if the injunction is well based on the information given, is just the information provided by the applicant the only reason the court is to take it into account to accept the petition, then what is the meaning of the application is well-grounded? One of these two rulings seems to be not very well coordinated. Article 12 says only information provided by the applicant. Article 8 say if the application is well-grounded. So which is a good one? Which one is to be taken into account by the judge or by the court to decide if the injunction should be or not admitted? The Article 16 of the preamble contributes with some more issues. It says the court should examine the application, including the issue of jurisdiction and the description of evidence, on the basis of the information provided in the application form. This would allow the court to examine prima facie the merits of the claim, and inter alia to exclude clearly unfounded claims or inadmissible applications. The examination should not need to be carried out by a judge. I mean, should be carried out by a clerk, for instance, or I don't know exactly. So we are introducing some more difficulties to this matter, because here in the preamble, it's not in the text, it's not in the Article 8, it's not in the Article 12, but if we use the preamble to interpret it, or to know exactly as interpreted, or to know what the legislator wants to say, we'll find that it's not finally quite easy. So is the court to examine the merits of the claim, to exclude clearly unfounded claims? What is an admissible application? I confess I don't know exactly. Yes, the merits of the claim, yes, of course, but this has not a lot to see with the Article 12, which is only the information provided by the applicant. In the Article 11 adds another question. The court shall reject the application if the claim is clearly unfounded. And my question as a judge should be how the judge or how the court is going to see if the claim is clearly unfounded, if the only information I have to count on is that one provided by the applicant, without having been verified by me. So you see, this is a bit of a trouble here. And it's also some more questions to come. The Article 38 of the Charter of Fundamental Rights of the EU provides that the policies of the Union will guarantee a high level of consumer protection. Says, interpreted by the court, European Court of Justice, that the courts examining a petition of EOP can request the creditor additional information on the contractual clauses to control their eventual abusiveness. And should the conjunction of European precepts oppose the national rule, this last should prevail. So, as you can see, probably I don't want to get into much more detail, because this is a bit all these things a bit tricky, a bit complicated, but you are using a different principles, a different combination. For instance, if you are using the EOP to claim an outstanding debt, ordinary debt, I should say, some principles wouldn't be applicable. But if you're using, or if you are a defendant in a claim made on contractual clauses regarding some kind of consumer protection contracts, for instance, it would be applicable all these kind of provisions in the special law, in the Article 38 of the Fundamental Rights of the EU. So in this case, you would see that could be some differences depending on if you are claiming a doubt coming from a consumer's contract, for instance, or if not. In one case, the court should have, it appears that the court should have the possibility to request the claimant, the creditor, additional information, because yes, the Court of Justice of the European Union says that the judges should always keep the possibility to control the abusive clauses in every contract from which the claimant is presenting a procedure, an injection. So this provision regarding the consumer's law shouldn't always be easy to combine with the provision of the EOP, or at least it seems so. So it's not just only the possibility for the judges to examine or to evaluate the petition, but also in a wide array of possibilities to evaluate the well-grounded petition, a well-grounded petition. So depending on the nature of the different petition, should be one or should be another. So at the end, it is not as clear as it should be for a judge to design or to evaluate the petition, the injunction, very swiftly and easily and smoothly. Not always would be, or that's my impression, my general impression. These are the different actions against rejection of the application. We've seen at the beginning of my presentation that this action against rejection of the application, it's a drawback. It's one of the main drawbacks of the EOP. We said that not only the possibilities of the court, of the judge to examine the jurisdiction and if the petition is well grounded or is not abused, it is not abusive, can become a problem, can become an issue to the swiftness desired by the legislator of the EOP, but also the possibilities of giving the defendant action, or even the claimant actions against rejection of the application. If the judge of the court finally decides to reject, to strike out the form claiming the EOP, we can find these 5 different possibilities. And on the principle, Article 11 says there shall be no right of appeal against the rejection of the application. Well, it's fine to me, but the preamble, it says something a bit worrying to me. We say, yes, there is to be no right of appeal against the rejection of the application, but this not preclude, however, a possible review of the decision rejecting the application at the same level of jurisdiction in accordance with national law. Well, I'm not sure in Spain what it means. I'm not sure. The same level of jurisdiction, what it means. You're not going to, you are not allowed to appeal to the same, I don't know, a side jurisdiction, a sidekick jurisdiction. I don't know exactly what it means, because in Spain, and I'm referring to my country, we don't have this possibility of challenge a judicial decision at the same level of jurisdiction. It always will go to a superior level of jurisdiction. If you are, if the application is rejected by a single judge court, for instance, it will go to a high court formed by 3 or more, up to, I think, 7 judges, but not to the same level of jurisdiction. So what it means, it's not quite clear to me. The Article 11.3 says the rejection of the application shall not prevent the claimant from pursuing the claim by means of a new application from an European order for payment or for any other procedure available under law of the member state. It's also a very wide provision that will allow the applicant to present again his application, his petition, or to go any other procedure available under the law of the member state. I believe it refers to an ordinary civil procedure. Yes, that's one. It's normal. In the case by a new application, I'm not very sure what it means, and if it's a brand new application, or it's an application correcting the defects found by the judge in the previous decision rejecting the application, or what it means exactly, I'm not very sure. Appeals to a superior level court of tribunal, yes, it is foreseen, the ruling, and of course it's a possibility. It's a possibility. To me, I'm not sure this is a very good idea, because if you are attempting to bring out a very swift procedure to get along with this minor or this outstanding debts, if you give the party the possibility to appeal or to challenge the rejection of the application to a superior level court of tribunal, you are, in some cases or in some country, it will cost very much time. So there's some contradiction in this situation. If you want to give the party the possibility to get a decision on enforcing some final decision very swift, very quickly, if you are giving them the opportunity to challenge and to appeal or to correct the defects found, or you are building a much complicated procedure, which doesn't combine very well to me with the general idea of creating a very quick procedure. And also, these provisions in the ruling seems not to take into account that some countries, they have administrative organs to decide applications. It's not the jurisdiction, it's not the general jurisdiction. It's some kind of, let's say, administrative courts or administrative organs to decide what this. And in those cases, I'm not very sure how can these combine with the possibility of appeal to a superior level court of tribunal. The court of tribunals they belong to jurisdiction. The administrative organs to decide application in some countries, they don't belong to jurisdiction. So where is how the fleet comes over? Yeah, I'm not very sure in this case. Well, this is the aim. I think we spoke a lot on this. So yes.
This is the end.
No. There's still some slides.
Oh, okay. Okay.
But it won't take much more time.
No. We are not time restricted, actually. So
I will try to be more swift myself.
We already have 2 or 3 questions for you. So
yes, but yeah. Let me finish with
sure.
quick references. This is the 5-step procedure. The 5-step procedure is as drawn in the law. Application form, court examines application, judge issues an European order of payments within 30 days of the application. The other party opposes the decision, and the other party must proceed with payment. These are the possibility 4 or 5. If the party opposes the decision, would be one thing, and if the other party must proceed with payment, is because he didn't oppose the decision. So this that's the same thing. And the main issue, as we seen before, is that many European orders for payment remain paralyzed in their subsequent enforcement. Taking into account that the order for payment has to be enforced in the debtor's country, if there has been not a voluntary payment, in the end, the creditor will have to sue the debtor abroad. That's the main problem, because in cross-border litigation, it is quite clear that in one side you have to present your injunction, you have to present your claiming, you have to present your application in one country, and finally, or in one moment particular, you have to enforce the EOP in the debtor's country. So I think this is the main practical problem. It's very difficult to get along with the enforcement of the order for payment in a different country. That's the problem. I think this is the main practical problem we do have with the EOP. But this is a case, a practical case. We have been finding how many companies that usually operate in Spain, for instance, that have a branch in Spanish territory. In most cases, their activity is the sale of credits, but that have registered office in other countries of the European Union. They even designate an attorney with address in Spain, leaving aside the issue of filing a claim by attorney in fact, which deserves a more extensive comment. I understand that in these cases, the international requirement, which is the foundation of the rule, is breached. Therefore, it's possible to reject such procedures because one of the parties is not domiciled in a member state other than the one in which the claim is filed. This is just an example. This is a decision of the Court of Justice. And well, this is not very well. It's not quite interesting. So, well, I think I'm done. I think I'm done and open to attend any question you have for me. I will be very pleased and eager to respond. What I could.
Thank you so much, Judge Pedro, for your presentation. Very educative and as usual. Very, very interesting. So I would like to ask you if you have any new cases in the small claim procedure that came upon to you during your practice. I mean, any new cases from the last time we met? Quite impossible. But I mean, what new is happening in the practical life? In the day-to-day life, because you are, of course, in touch with the practical part of these procedures, and of course, you also are able to teach these theories. But in the practical life, what is new in this domain? What can you share with us?
Thank you. Thank you.
If not a secret, of course.
No, but unfortunately, I cannot answer you. I'm not actually in the jurisdiction. I'm working for the General Counsel for the Judiciary, so I'm off jurisdiction, and I was off the jurisdiction when we met before, and actually I'm keeping the situation. I'm maintaining myself out of the jurisdiction, so no news. And but yes, I can tell you that in practical ways, I usually try to review the case law regarding the main procedures, European procedures. And one thing I can tell you is that it seems that the Spanish lawyers, for instance, they do not present a lot of EOPs and outside Spain. And if I'm not wrong, I think the number of EOPs presented in Spain against the Spanish debtors are lowering dramatically. So I think the tool is not. I don't know if it is really scarcely new by people, by judges, by lawyers. But I can tell you that within judges, it is really not very well known. Yes, I do speak with a lot of colleagues, and they don't know exactly what it is. And we receive from time to time in the international relations department, which I am actually leading, some questions on this subject, because they don't know exactly how it goes. What it means in practical terms that they don't receive a lot of them. Mm-hmm. In other case, they shouldn't ask for some support to us. So I think, unfortunately, there's not a large number of EOPs coming to Spain or going out from other country. I think it's not very well. My belief is that the procedure is very difficult to enforce. I think the practical conclusion, if I should say so, is that lawyers doesn't believe, mm-hmm. are not quite confident on how to enforce the decision in a foreign country.
Is it due to the transnational form of application of these matters, or I mean, to what it is linked, this difficulty of application? With the abolition of exequatur, it should be easier. That is the goal of the law, basically, to abolish exequatur, to make it easier for the internal market to participate with this kind of tool to boost the economy and the business activities among the member states, among the partners, among the business companies. But it's true because, for example, at the beginning of this lecture, Aredin has shared some statistics with, from the Slovenian judiciary system, and it is the same as you have mentioned. I mean, not so many cases, of course, in the framework of EOP, and also in ESCP. I mean, the small claims are also not that many as they should be, because they are small claims and the fees are not so high. But still, even there, I mean, the amount is not what we would expect. So one thing is sure, the tools are not so well known among the specialists, amongst the lawyers, for example, so they don't propose this to the client, and the client also don't really need lawyers in order to use these tools, because they are very facilitated in order to be used by anybody. So maybe that might be, I don't know, I mean, that might be an issue. But what would you propose as a remedy for this situation, and what would you propose also for companies? I mean, in order to avoid problems, bringing court cases, for example, in order to get their money back or something like that? What can you propose to companies to avoid these issues? Thank you.
Yes, thank you, Mary, for your question. It's a very interesting question. On one hand, I would say, what do you think is the main user of this the UOP? It's a private user. It's an ordinary people. Let's say me, if I have a problem anywhere in Europe, am I going to use the UOP as a tool to recover my debt, my outstanding debt? It's not likely. It's not likely, because the amount of my debt wouldn't make it worth it to even to use it by myself. Because if someone owes me, let's say a hotel or somewhere in Berlin or something, I had a problem in London, or well, not in London, in I don't know, in Paris, and I'm claiming 200 euros. And am I going to waste my time using a form presented as for 200 euros? In fact, it's not likely. One thing it's clear to me is that the ordinary people, I mean, people by themselves, they are not using the UOP at all in any case whatsoever, because they don't want to. They rather go to the insurance office to get back the money, or if they have this kind of travel insurance to cover these possibilities or these difficulties, or the Spanish average people, they don't trust. Didn't trust that the right of the that they don't trust the jurisdiction to get along with this kind of plan in a reasonable time. So they just quit, or they just abandon the claim, if not it's too high, of course. They use the insurance company to cover the damages, or whatever. And what I find, yes, it is the perfect user are the companies claiming this small amount. And these companies, for instance, providers of commodities, telephone lines, or commodities in general, yes, to them it's a good idea to use a UOP. But the problem with this is also they are very small amounts, because when a commodity company, let's say, for instance, an internet provider, it doesn't wait more than 2 months to stop the service if someone is not paid for. For instance, in 1 month could be 50 euros, 2 months could be 100 euros, 4 months could be 200 euros. And even in that case, once the commodity, once the service is cut down, so it's 200 euros, and the company has to count on a lawyer to present the UP outside the national system, and it would certainly cost much more than 200 euros. So they abandon, simply speaking. So that's the problem. In fact, when I was a judge, I am going to tell you one thing, very, very funny. Oh, I'm not so sure if it's funny or it's terrible. But when I was a civil judge, 80% of the injunctions, of the petitions or the claimings were made by companies. 80%, probably more than 80%, and they were very small claims, 100 and something euros, 250 euros, 400 euros, because they belong to commodities. 80%, and only the 20% left belong to big companies or breaching of important contracts or very important issues. But the 80% in an ordinary Spanish civil court belong to these very small claims under, let's say, 2,000 euros, 3,000 euros as a maximum. So in every case of this were companies. They're not people. They were companies against people.
Yes, yeah. Listen. I mean, is it due to maybe the lack of legal education, for example? Maybe these kind of activities that we are doing, awareness raising about the EOP and ESCP can help improve this situation. I mean, even if individuals want to use it, because as you mentioned, for 100 euros, filling the form and expecting the money back, and then the other side can say, no, I'm not paying. And then the case again goes to the national court. So again, yes, there is this problem that it will be just a time waste, and we're starting from zero. So yeah, that may be acceptable. So what if we put incentive on awareness raising, on educating the lawyers as we are doing now? Do you think maybe this situation will change in the future? Or do you think we really need to amend in a way the Brussels regulations, maybe to improve the amount, because it has already been improved from 2,500 to 5,000, but still it's the same picture is there, the same statistics, it's not really growing. I mean, maybe to put it to 7,500, for example, or I don't know. What do you think about this proposal?
Yes, you're right. You're right. I think a good communication policy is a good idea. Of course, it always is. It always is. I mean, the average citizen doesn't know practically nothing of most questions, and that's the average situation throughout Europe, and that's the same question to all. But yes, a good policy has. For instance, I have seen in former times. I don't see it actually in much cases. The information given to the passengers, for instance, in airports. If you are expecting for more than 4 hours, you have a right to something. If you are not admitted to a flight, you have this right. And these big plates all over the place, all over the airports, normally has given a very good idea. And it has been a very good idea. It has very good information to people and to travelers. But I wonder why actually you don't find this kind of advices. Could it be because the citizens were too much
yeah, that's true. Too much information. Yeah,
the company said, no, please don't tell the people they have some rights, because I want to be sued by them. So I prefer to give them a sandwich or something like that, and no more trouble. Because that's shocking to me. And yes, I think the good communication, good information, to print some leaflets or some information to people. I think it always is a very good idea. And even in that case, yes, increasing the range of the amount of it would also a very good idea. Because this would prevent people to go into the ordinary civil procedures and using the EOP, which would be a very good idea and would be a way to extend the range of the use of procedure. Yes, I agree with that. I'm totally in favor of that idea.